So I cut 5 inches off my hair. It just feels really weird right now. But I wanted to start to discuss some of that document drop from last week. Of course, as you know, the deadline for motions was on November 17th. And the night before the deadline, Anne did try to get an extension, but Judge Hippler denied that. Now, the document I want to talk about first is the motion for a Franks hearing. So let's take a look at that motion. Says, comes now Brian C. Koberger by and through his attorney of record and moves the court to conduct a Franks hearing. The motion is made pursuant to the Fourth Amendment of the United States Constitution and Article 1, Section 17 of the Idaho Constitution and Franks versus Delaware. A proffer and exhibits are filed contemporaneously in support in accordance with State versus Fisher. The parties stipulate to the sealing of the proffer and exhibits. A stipulation is filed contemporaneously. The under seal proffer and exhibits are being provided to opposing counsel and court staff via email on the date of the motion. Hand delivery to the court for in-person filing will occur no later than November 18th, 2024. Sorry, it's really windy out here. But what a Franks motion is to try to get a Franks hearing, which is very rare. You can file, but it's rare that you will actually get the hearing. And the reason why is there's certain criteria that have to be met. And it came about from a case called Franks versus Delaware that was a landmark Supreme Court ruling. And I'm going to show a little video with the background of Franks versus Delaware. Now, if you already know about Franks versus Delaware, you can go ahead and fast forward, but it's always a good refresher to have.
Criminal defense lawyers often challenge the sufficiency of facts in an affidavit supporting a search warrant. But can a defendant challenge the veracity of such an affidavit? The United States Supreme Court considered that question in the 1978 case of Franks versus Delaware. Cynthia, a woman in Dover, was sexually assaulted by a man who broke into her home and threatened her with a knife. She reported to police that the assailant had worn a white knit thermal undershirt, a brown leather coat, and a dark knit cap. Investigators quickly focused on Jerome Franks, who'd been arrested regarding a different assault and who'd possibly incriminated himself in Cynthia's attack. In an affidavit seeking a warrant to search Franks' apartment, the investigators said that Franks' work supervisor told investigators that Franks regularly wore a white knit thermal undershirt, a brown leather jacket, and a dark green knit hat. The magistrate granted the warrant, and a search of Franks' apartment revealed evidence tying him to Cynthia's attack. Before trial, Franks moved to suppress the evidence from the search, claiming that his work supervisors would testify that they never spoke to the investigators. Franks also claimed that the affidavit mischaracterized what his supervisors did tell other officers. The trial court held that defendants couldn't challenge the truthfulness of statements in a search warrant affidavit. The court admitted the evidence from Franks' apartment, and he was convicted. The Delaware Supreme Court affirmed, agreeing that criminal defendants have no right to challenge the veracity of statements in search warrant affidavits. Because different state and federal courts disagreed on this issue, the United States Supreme Court granted cert. The court considered whether the Fourth and 14th Amendments ever grant criminal defendants the right to challenge the truthfulness of statements made in a search warrant affidavit. The court answered yes, that under certain circumstances, the Fourth and 14th Amendments require that defendants be allowed to challenge the truthfulness of statements made in a search warrant affidavit. Justice Blackmun explained that the Fourth Amendment allows a search warrant to be issued only if a statement made under oath or affirmation establishes probable cause. The oath or affirmation requirement emphasizes the importance that the affidavit be truthful. Because a warrant affidavit can be based on hearsay or on the word of anonymous informants, absolute truthfulness isn't expected. But a police officer may not knowingly make a false statement or act with reckless disregard for the truth. Blackmun weighed several policy considerations favoring and disfavoring post-search challenges to the veracity of warrant affidavits and then noted that defendants had long been allowed to challenge the sufficiency of the facts set forth in a warrant affidavit. The court concluded that there was no good reason to distinguish between challenges to the sufficiency of an affidavit and challenges to its integrity. Subject to several limitations, the court ruled that such challenges must be allowed. Search warrants and their supporting affidavits are presumed to be valid. A challenge must allege and offer proof that an affidavit includes a deliberate falsehood or a reckless disregard for the truth. The challenge must point out which part of the warrant is false, and it must include sworn witness statements. Finally, if the evidentiary requirements are satisfied, the supposed falsity is disregarded, and there still remains sufficient evidence to support probable cause, then the challenge fails. But if the remaining content doesn't establish probable cause, then a hearing must be held. Here, Delaware's absolute prohibition on challenges to the veracity of warrant affidavits meant that state courts didn't consider the sufficiency of Franks' motion. So, the Supreme Court reversed and remanded for reconsideration. Associate Justice Rehnquist dissented, arguing that the neutral magistrate's determination regarding the sufficiency of a warrant affidavit was enough to satisfy the Fourth Amendment. Rehnquist expressed concern that allowing impeachment of the magistrate's decision regarding a search warrant would overtax trial courts. He was also concerned that creative lawyers would subvert the court's limits on challenges to the truthfulness of warrant affidavits. Rehnquist would have affirmed the lower court judgment. The new procedure authorized in Franks v. Delaware didn't help Jerome Franks very much. On remand, the Delaware Supreme Court ruled that even ignoring the challenged paragraphs from the warrant affidavit in Franks' case, the affidavit still contains sufficient facts to establish probable cause. The search warrant in his case was affirmed, as was his conviction.
Okay, I had to move into my car because it is just way too windy out there. Now that video came from Quimby, which is a great website to get legal summaries. You do have to have a subscription though, but I just thought it was a great resource for summarizing quickly what the Franks versus Delaware ruling was all about. Now, prior to that ruling, you could not challenge the veracity of a warrant, and of course now you can, but it set up specific criteria that was discussed in the video, but let's go over that criteria again. So it says to mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. The allegation of deliberate falsehood or reckless disregard must point out specifically with supporting reasons the portion of the warrant affidavit that is claimed to be false. It also must be accompanied by an offer of proof, that's the proffer, including affidavits or sworn or otherwise reliable statements of witnesses or a satisfactory explanation of their absence. Now moving on to the second part, if these requirements as to allegations and offer of proof are met, and if, when material that is subject of the alleged falsity or reckless disregard is set to one side, there remains sufficient content in the warrant affidavit to support a finding of probable cause, no hearing is required. But if the remaining content is insufficient, the defendant is entitled under the 4th and 14th Amendments to a hearing. If after a hearing, a defendant establishes by a preponderance of the evidence that the false statement was included in the affidavit by the affiant knowingly and intentionally or with reckless disregard for the truth, and the false statement was necessary to the finding of probable cause, then the search warrant must be voided and the fruits of the search excluded from the trial to the same extent as if probable cause was lacking on the face of the affidavit. So, it's not enough to prove that there was a knowingly false statement or reckless disregard for the truth. It also has to show that without those items in there, that there was also no longer probable cause. So those two steps have to be met to be granted a hearing, and that's why it's very hard to get one of those hearings granted. Because a lot of times, it's hard to prove that something that was included in an affidavit was done, like, purposely with, like, intent to deceive, with reckless regard to the truth, or that something was omitted purposely. And we'll see that when we discuss that Fisher ruling, how they decided that a Franks hearing wasn't warranted. Now, one of the things I wanted to talk about was the proof of offer, or offer of proof, the proffer, because you'll see there's been a few content creators over the last couple days that are claiming that in this situation that it's something that it really isn't. So let's go over the definition of a proffer. So a proffer has two separate meanings depending on its context. The meaning differs on whether it is used in a trial or evidentiary hearing setting or a criminal matter, either federal or state systems. First, if the term is used regarding a trial or evidentiary hearing setting, it is referring to an attorney putting things on the record solely for appellate purposes outside the presence of a jury, or knowing that the presiding judge isn't going to consider same during the consideration of the motion. Many appellate standards require the appellant to show certain characteristics concerning the testimony. For example, a defense attorney may want the barred expert to testify as to the specifics of a test they perform to provide context and the specifics of the procedures to the appellate court. It is oftentimes necessary to proffer a witness's testimony if the court is otherwise barring the witness from testifying. Now, you'll see that when Judge Hippler declined to have the two experts testify at the death penalty hearing, that he accepted their proffers. So he's going to review their proffers in part of his decision making. He didn't feel he needed them to testify, but their proffers are basically what I like to call it is it's like a preview of what they would have testified to had they been up on the stand. So it is what their testimony would be, what they're testifying to. So when we go on, the second use of proffer is being used in the criminal content. It essentially means one of two things. In the federal criminal context, a defendant will receive a proffer letter from the Assistant United States Attorney prosecuting the case, giving them immunity for all statements made during the proffer. We discuss these issues elsewhere. Okay, this is in the blog. These sessions are intended to benefit the defendant by assisting the government and law enforcement in making further arrests, while assisting the defendant to receive a more favorable sentence later in the case through a positive recommendation from the United States Attorney's Office to the sentencing judge. What that's saying is that the second use is like a deal for a confidential informant. They're being given an offer and they can accept it to provide certain testimony. But the way proffer is being used in this context is Anne and the defense team are submitting their proof, their offer of proof, to Judge Hippler as to why they should get a Franks hearing. So her proffer and her exhibits are going to include why there's a violation of the Fourth Amendment. She's going to outline what she believes was lied about or omitted on the affidavits. It's what she is expected to testify about if a Franks hearing is granted. So if you heard Pavarotti and even Rory the other night saying that this had to do with a confidential informant, that this proffer that Anne is putting forth is a confidential agreement that they found with an informant, that is not what the proffer is that she's putting forth. Now, it may not be, there may be a confidential informant involved in this case, and it's possible they're trying to get the words of a confidential informant struck from an affidavit, but the proffer she is putting forth for the Franks hearing is what she's expected to testify to if given the hearing. Okay. Now, the reason why Pavarotti is so sure it has to do with a confidential informant is because he kind of glossed over the case that Anne cited. We'll look again at the motion. Okay, so it says a proffer and exhibits are filed contemporaneously in support in accordance with State versus Fisher. So we're going to look at State versus Fisher. And it was a case that went to the Supreme Court of Idaho in 2004. So the appellant is seeking relief from his judgments and convictions for possession of a controlled substance and trafficking, both felonies. The appellant appeals the district court's order denying him a Franks evidentiary hearing because the district court improperly held an ex parte in-camera hearing to arrive at its decision. The judgment of the district court is affirmed. So the factual background was that the magistrate judge issued a warrant to search the property of Daniel Eugene Fisher based upon the sworn testimonies of Detective Drumright, a confidential informant, and based upon references to statements of a concerned citizen. The judge determined there is probable cause to believe there is methamphetamine, also ongoing manufacture, attempted manufacture of methamphetamine. The search warrant was executed on January 19, 2001, resulting in a charge of felony possession, misdemeanor possession, and misdemeanor possession of paraphernalia. As a condition of release, Fisher consented to be searched at any time. While case 27975 was still pending, the police executed a search of Fisher's property and discovered methamphetamine, as well as several items consistent with the manufacture of methamphetamine, which resulted in an additional charge. Fisher moved to compel the state to produce inter alia the name of the confidential informant used to secure the warrant. The state objected, asserting that the identity of the informant was privileged. Although it appears there was no pending motion to suppress, the district court ordered a Franks sufficiency hearing on its May 10, 2001 pretrial order. Fisher then filed a motion to suppress and in limine an affidavit in support of motion to suppress. Fisher's affidavit alleged that Drumright presented to the magistrate false information, presented intentionally or with reckless disregard for the truth. Specifically, Fisher alleged the color of his residence and the representation that there was an attached Porsche on the south side are false. Drumright's testimony that he had been to the residence on previous occasions is false. Also, the testimony of Drumright concerning a very large generator on the property of Fisher is false. Moreover, Drumright's statement that he and Corporal Wills located a suspected vehicle that Wellen was driving on Fisher's property is false. Wellen was an individual accused of a separate crime that brought the detectives into initial contact with Fisher. Fisher also claims that the informant's entire story implicating him is a fabrication. The testimony of Drumright calling upon the informant for verification regarding the existence of structures on the Fisher property and their location is inaccurate as hereinafter set forth and reflects a reckless disregard for the truth. Further, the statement that there is a metal-type structure or storage shed or metal container, cargo type container, large metal container, or Conex type box on the property is false. Fisher admits that he has dogs, but disputes they are vicious. Lastly, Fisher disputes the neighborhood informant because no one who has lived in the neighborhood and visited the Fisher property would make statements about sheds and containers. Fisher also filed another motion to compel the state to disclose the identity of the informant and requested an in-camera hearing by the court on this question. On July 2, 2001, the district court denied Fisher's motion to disclose the identity of the informant, but granted his motion for an in-camera hearing and concluded Fisher met the threshold showing and is entitled to a Franks hearing. The district court held the in-camera hearing on July 26th. After conducting the in-camera hearing, the district court denied Fisher's request for a Franks hearing in its August 8, 2001 opinion and order, despite granting the Franks hearing in its July 2nd opinion and order. Thereafter, the parties entered a plea agreement whereby Fisher pled guilty to the felonies and the state agreed to dismiss the misdemeanors and allow Fisher to appeal the district court's order denying him the right to a Franks hearing. Fisher thereafter filed timely appeals from the judgments of conviction to this court. Standard of review. In reviewing the issuance of a search warrant by a magistrate, the appellate court's function is limited to ensuring that the magistrate had a substantial basis for concluding that probable cause existed, with great deference paid to the magistrate's determination. Our inquiry encompasses the totality of circumstances disclosed by record. Analysis. The district court did not err in ruling that Fisher was not entitled to a Franks hearing. These cases turn on whether Fisher was entitled to a Franks hearing. The state concedes that the district court procedurally erred by holding an ex parte in-camera hearing. However, the state contends any error was harmless because Fisher was not entitled to a Franks hearing. Where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit, and if allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held at the defendant's request. And as we discussed, that came from Franks versus Delaware. It says, Idaho has adopted the rule established in Franks and has made clear that a warrant is valid even if probable cause is based on false evidence, as long as the evidence is not presented intentionally or with reckless disregard for the truth. The defendant bears the burden to prove by a preponderance of the evidence that the warrant affidavit contains intentional or reckless falsehoods. To justify a Franks hearing, false testimony must be made deliberately or recklessly by a governmental affiant, not by a non-governmental informant. Franks evidentiary hearing is not to be lightly granted, but may be allowed only when the defendant makes a substantial preliminary showing of an intentional or reckless falsehood. In other words, a defendant is not automatically entitled to an evidentiary hearing on his challenge to the veracity of statements made at a probable cause hearing. Before a Franks hearing is granted, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of a deliberate falsehood or of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof, the proffer. So this is where Anne's saying she's submitting a proffer in accordance with this case, because this was an Idaho case where they were trying to get a Franks hearing, and they submitted their proffer. They should point out specifically the portion of the warrant affidavit that is claimed to be false, and they should be accompanied by a statement of supporting reasons. Affidavits or sworn or otherwise reliable statements of witnesses should be furnished or their absence satisfactorily explained. Allegations of negligent or innocent mistake are insufficient. Thus, Fisher's allegations that Drumwhite testified to falsehoods must be specific, supported with reasons, and offer of proof, the proffer, not conclusory, and the state action complained of was deliberate, intentional, reckless, and not just negligent to justify a Franks hearing. Moreover, if these requirements are met, and if when material that is subject of the alleged falsity or reckless disregard is set to one side, there remains sufficient content in the warrant affidavit to support a finding of probable cause, no hearing is required. First, Fisher contends that Drumwright falsely testified to the color of his residence and that there was a porch on the south side of the residence. Fisher states it's a matter of public record that the residence is not off-white and there is no attached porch on the side because the Bonner County assessor has a color photograph of the residence. Fisher's allegation is specific, but he failed to support his allegation by an offer of proof. Fisher claims that the assessor has a photograph, but he fails to state the exact color of his residence. Therefore, Fisher's allegation is conclusory. Regardless, Fisher fails to show that Drumwright's mistake in the existence of a porch and the color of his house was made recklessly, deliberately, or intentionally. Mistaking the color of a house or the existence of a porch could easily be negligent only, especially if the true color of the house is a light color resembling off-white. Negligence alone does not justify a Franks hearing. Fisher claims that he did not have personal contact with Drumwright or that Drumwright and Corporal Wills located a suspected vehicle that Wellen, a man accused of a previous crime that brought the detectives into initial contact with Fisher, was driving. Fisher said that he had only had contact with 3 officers, none of which were Drumwright. However, Fisher fails to state or show that Drumwright's false assertion was made deliberately, intentionally, or recklessly. Again, mere negligence will not justify a Franks hearing. Showing deliberate, intentional, and recklessness is a high hurdle for Fisher that he has failed to show on this contention. Next, Fisher claims Drumwright's statement that Fisher has a large generator is false. Fisher states there is a generator on my property, but it is in the 4,000 watt capacity, which is not large. Fisher's assertion is specific, but it is also conclusory. There is no authority for rating the size of a generator. Furthermore, reasonable minds may differ as to whether a particular generator is large. Fisher should have provided reasons as to why the generator is not large. Thus, Drumwright's statement may not even be false. Notwithstanding, Fisher fails to show that such allegation was made intentionally, recklessly, or deliberately. Also, Fisher alleges in his affidavit that the entire story testified to by the informant is a fabrication because the informant did not smoke or buy methamphetamine from Fisher. However, Fisher did not provide any offer of proof. Rather, he made only a conclusory statement. Moreover, even if the informant lied, Drumwright did not create the lie, but perhaps repeated the lie to the magistrate who issued the warrant. Therefore, Fisher failed to justify a Franks hearing on the allegation because the alleged false statement was not created by the governmental affiant. Fisher makes additional arguments regarding the information provided by the informant. Fisher disputes that there was ever a hot plate in use at the residence, that he and his wife owned a blender capable of being used to grind pills of any kind, and that the informant saw Fisher with methamphetamine 5 or 6 times within about a month, and it was normally in a blue Ziploc baggie. However, Fisher's claims are conclusory without being supported with an offer of proof. Furthermore, even if Fisher is correct and the informant is incorrect, there is no evidence that the governmental affiant made deliberate, intentional, or reckless false statements. At worst, Drumright could have been negligent in believing the confidential informant. Negligence alone, however, will not justify a Franks hearing. Fisher also takes issue with Drumright's testimony, which was verified by the informant. Specifically, Fisher alleges the statement that there is a metal-type storage shed or metal container, cargo-type container, large metal container, or a Conex-type box on the property is false. The statement that there is a covered utility type or enclosed utility trailer on the property is false. Fisher's allegations are specific as set forth in his affidavit, but his assertions lack additional forms of support, such as pictures, witness testimony, etc. Moreover, such a claim may support negligence on the part of Drumright, but there is no showing that such statements are deliberate, intentional, or reckless falsities. Therefore, Fisher has not met the burden for a Franks hearing made on these allegations. Additionally, Fisher states the representation that the dogs of Fisher are rather vicious, and a couple of deputies from the area stated Fisher has dogs who are trained to attack is untrue. Fisher admits that he has dogs, but denied they are trained to attack. Fisher's allegation is specific, but there is no indication that such a false statement was made deliberately, intentionally, or recklessly. Moreover, even if such statements were deliberate, intentional, or reckless, there is no direct connection with the dogs and the probable cause for methamphetamine violation. In other words, the statement was not necessary to the finding of probable cause, and as such, a Franks hearing is not justified, even if the statements were false. Lastly, Fisher claims that the testimony of the neighborhood confidential informant is false because there is no one who has lived in the neighborhood and visited the Fisher property who would say that there has been a large metal shed or metal container, cargo-type container, or Conex-type box on the Fisher property. Again, Fisher's statement is specific but does not show that Drumright was deliberate, intentional, or reckless, even when assuming the statement was false. Furthermore, there were multiple sources of information provided in the search warrant. As such, the neighborhood confidential informant may not be necessary to a finding of probable cause. In conclusion, we hold that Fisher was not entitled to a Franks hearing because he did not make the requisite substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard from the truth was included by the affiant in the warrant affidavit, and the false statement was necessary to a finding of probable cause. However, the district court committed harmless procedural error by granting Fisher's request for a Franks hearing and then denying the request after an ex parte in-camera hearing. Then it talks some more about the error about granting that ex parte hearing, but we're not going to go through all that. And it says, this court finds that Fisher failed to make a preliminary showing that he was entitled to a Franks hearing. Therefore, the district court's error in conducting the hearing was harmless because Fisher had no right to the hearing. Also, the state was not required to cross-appeal the July 2nd, 2001 order because the state was not seeking affirmative release. Based on the court's holding, Fisher's additional issues need not be addressed. Conclusion. In conclusion, the court affirms that the district court, on grounds different than those used by the district court, Fisher failed to make a preliminary showing that he was entitled to a Franks hearing. Therefore, the district court's error in conducting the ex parte in-camera hearing was harmless because Fisher had no right to the hearing. Also, the state was not required, so this basically just repeats the first part. So we can see there was a lot more to that case than just what a confidential informant had stated. He was also trying to say that the law enforcement officer had made false statements with reckless disregard. And you can see how it is a high burden because each of those things, while maybe they weren't correct, maybe they weren't completely truthful, were not considered to be reckless or intentional. Negligence, as they said several times, is not reason for a Franks hearing. So, when I say it's an uphill battle for Anne to be granted this Franks hearing, it's an uphill battle. I've been steadfast that my personal opinion is she won't be granted the hearing. I will be very surprised if Judge Hippler grants it. Now, if he grants it, you can all say I told you so. That's fine. But I just don't feel like I'm trying to figure out what she's even, what could be in that proffer. Is she trying to say that the phone data was like reckless disregard for the truth, like they intentionally put in incorrect phone data? Because it sounds like from the hearings that Mowry was understanding from Agent Balance that draft cast report was the correct data. So if the judge looks at that and says, no, I believe they were putting this in here believing that data was correct, that's not intentionally lying about anything. That's not disregard for the truth. If Mowry put that in there believing that was the correct data, that's what happens. Also, I heard some people saying that it's because they admitted about the 3 DNA. Well, there is nothing out there that says that exculpatory evidence has to be included in a search warrant. So that's not anything that, and honestly, if they put in there that there were 3 other DNA, they could have qualified it with were not considered to be suspect DNA based on where they were found. So that wouldn't have impacted any of the judges, in my opinion, that signed these warrants, because Koberger's DNA was the one that was on the sheath. So, or that they believed was on the sheath. His car is what they believed is on video, etc. Now, as far as the IgG goes, I don't think that's something that was recklessly indifferent to the truth of not including, because they've maintained it was just a tip. And also, IgG, if anything, if they included it in the affidavits that they did get information through IgG, to me would just have solidified the judges and magistrates signing it, because that would be further proof that you're on the right, that this guy's the suspect. So even without the dad's match, but they went that extra step of getting the STR match with the dad's DNA because of federal protocol. But federal internal guidelines, like the FBI's internal guidelines about IgG, are not law. So if the FBI violates those guidelines, that's not illegal, that's not unconstitutional. SCOTUS has not ruled that IgG is unconstitutional, that using IgG. They have also not ruled that going in a back door to a website like 23andMe is unconstitutional. A company's terms of service are not a law. They're just like a suggestion. So it's not illegal, like to use a private account to get into 23andMe if you're a law enforcement agent. Does it violate the terms of service? Yeah. But there's been no court cases at SCOTUS that have said this is unconstitutional, this is illegal. Now, what I think is Logston really is itching to get this case up to the Supreme Court so he can get a ruling about IgG and constitutionality. But as of it stands right now, there's nothing that says this IgG, that it was unconstitutional to use it as a tip to get to Koberger. And I don't think Hippler's going to play along with that. My personal feeling is he'll say, if your client's found guilty, then you can appeal it all you want up to the Supreme Court. But we're not going to play that here. So we shall see. It'll be interesting. Now, let me know what you think that Anne believes is the lie in these affidavits. And also let me know which of the other documents in that document drop that you would like me to cover next.